And for those of you joining from other parts of the world, it's a great pleasure to welcome you to HKIAC's inaugural lecture as part of the Seoul ADR Festival. This morning, it's my great pleasure to introduce to you Mr. Justice Robert Tang, who will be delivering this year's lecture. Robert has led a very long and prestigious legal career in Hong Kong. He spent 34 years at the bar, where he took Silk, QC and SC, following which he was appointed to the judiciary, starting first of all at the Court of First Instance, and then being appointed to the Court of Appeal, and then in relatively short order to the Court of Final Appeal, Hong Kong's highest court. There he served for 6 years before his retirement in 2018. And when he stood down in 2018, he was awarded the Grand Bohemia Medal, which is Hong Kong's highest honor. Also in 2018, Justice Tang then joined HKIAC's council, our governing board, and we were very privileged and honored to welcome him onto the council. And he also joined our Finance and Administration Committee. And in some ways, this is Justice Tang's coming full circle in terms of HKIAC, because he was one of the founding members of the institution back in 1985. So it's our great pleasure and our great privilege to have him work with us now in his career as an international arbitrator. So Justice Tang, thank you very much. We're very much looking forward to your lecture this morning on arbitration, a collaborative effort. Before I hand over, may I just let the audience know that we will have an opportunity for some questions for Justice Tang at the end of his lecture. So if you do have questions, please put them in the chat, and then I will come back to those at the end. Thank you very much. Over to you, Justice Tang. Thank you.
Thank you, Sarah. Good morning. Thank you for giving me the opportunity to take part. Lord Mustill said, ideally, the handling of arbitral disputes should resemble a relay race. He visualized the baton passing from the arbitrators, who decide who was right, to the court, who uses its coercive power to enforce the award when needed. Team effort is essential in the relay race. One would take care to field the best runners. But arbitration is a relay race with a difference, a race in which the competing teams share the last two runners. A party has a say in the composition of the arbitrators. The matter of the enforcement court is complicated. Enforcement courts may include the court of the seat of the arbitration, the court of the venue of the arbitration, and the courts where the successful parties seeks the enforcement of the award, usually because they are as readily realizable assets in their jurisdiction. There may be, of course, more than one. I'll call this last the enforcement court. Each of these courts has its different function. The court of enforcement is normally the most important, because that is where the successful party will seek recovery. I'll deal with them in greater length below. In this talk, I want to concentrate on genuine, complex international commercial disputes. My idea of a genuine dispute is one in which the parties genuinely and reasonably believe they have a viable case on liability and no quantum. The merits do not have to be divided 50-50, but both parties have an appreciable chance of success, completely or partially, on liability and or quantum. When the merits are one-sided, disputes are likely to be settled, and there should be no arbitration. Sometimes, even one-sided disputes go to arbitration. They are normally pursued or defended for technical reasons, for example, for time or for a more favorable settlement. However, when there is an arbitration, one has to take it seriously The most dangerous mistake one can make is to be overconfident. There are disputes where one party has reason to be confident about its chances. But the worst mistake a party can make is to take success for granted and does not devote the necessary time and money to the arbitration. Many a claim has been lost because of that. My advice is never take anything for granted. Lawyers know that, but sometimes they have difficulty convincing their clients. I'm digressing and should return to what I really want to say. Each party and its representative have a common aim, success in the arbitration. As in a race, one's success will depend on how well one's team is put together, as well as planning and logistics. The choice of one's representatives. In commercial disputes, they will normally be lawyers. This is, of course, in the hands of the parties. In complex international commercial disputes, very often, the parties have their own in-house legal team, so choosing a suitable team of representatives should not be a problem. I have nothing more to say about that. I imagine that international companies, before doing business in a foreign country, will do its research, and the availability of acceptable dispute resolution mechanism will be one of the factors it considers. I presume arbitration will be the chosen method of dispute resolution. Mediation is very often the first step, and many disputes are resolved at that stage. But this talk is not about mediation. I do not imagine that companies will begin their negotiations with discussions about arbitration. I imagine they will take resolution of disputes by arbitration for granted. I expect actual discussion on details would come after all the commercial terms have been agreed, and therefore often at a time of maximum goodwill and optimism. Few agreements end up in a dispute, so the parties are likely to be quite relaxed about it. It is unlikely that the agreement regarding dispute resolution would prove to be a deal breaker. Rules regarding international commercial arbitration and their enforcement are well known and largely standardized. Basically, we're talking about the UNCITRAL rules, which have been adopted by 85 states in a total of 118 jurisdictions. The rules are reasonable and user-friendly. The vital role of fair, efficient, and rules-based dispute resolution in international trade is understood, and I'm glad to say respected even in countries whose notion of the rule of law is different from the common understanding of developed countries. If there are difficulties, they are more likely to be the result of inexperience or inefficiency rather than deliberate policy. Governments, even powerful governments, do not stand in the way of arbitration. They embrace it. I believe they understand that fair, efficient, and rules-based method of dispute resolution is essential to foster international trade. I note that the PRC, in its recent 5-year plan, has reiterated that the promotion of international arbitration in Hong Kong is an important plank of its policy. Although the parties can readily agree on arbitration to resolve their disputes, there are important details which have to be agreed. They should be considered carefully. These details include the choice of law, the language of the arbitration, the seat of the arbitration, the venue, and the choice of an administrator, if any. The choice of law perhaps presents the least difficulty. Parties, of course, will obtain advice from the lawyers before they agree to a system of law, particularly one with which they are not familiar. It is quite common in arbitrations for expert evidence on the applicable law to be available if necessary. Arbitrators should have no difficulty dealing with such evidence. Also, I suspect that there are more similarities than differences in international commercial laws in the major trading companies. Anyway, the party would wish to be advised of the possible impact of a system of law before they agree to its choice. Arbitrators and lawyers trained in one system of law should have no difficulty coping when a different law is chosen. I'll say no more about this. The choice of language. This is more complicated. In international disputes, often the parties have different native languages, although they usually share a common language. That is often English, the lingua franca of international commerce. Maybe that is why English is often chosen as the language of the arbitration. If English is not the native language of either party, that should not give rise to any difficulty. For example, one party may be Korean or Japanese, and the other party Chinese, but English is the common language. In such cases, it should not surprise if they choose English as the language of the arbitration. But that is not always the case. I've been involved in arbitrations where one party was Chinese and the other Korean. The chosen language was English. But I have also been involved in arbitrations where one party is Chinese and the other Japanese. Although practically, all the documents and correspondence were in English. In a particular case, the agreed language of the arbitration was Chinese. At the procedural stages, the parties adopted a bilingual approach, English and Chinese. Eventually, the parties agreed that at the hearing, English should be used. All the submissions were made in English, and the award to be rendered in English as well. Some issues of law were involved, and the law of the arbitration was the law of the BVI. All the authorities, and there were quite a number, were in English. So in the choice of language, I believe practicality should be an important consideration. Where English is not the native language of either party, and English was used as the common language of the transaction, it makes sense for the language of the arbitration to be in English too. Sometimes, however, English is the native language of one of the parties, although English was used as the means of communication between the parties. Let's say a Chinese party and an American party. The non-native English-speaking side might wonder, what should they do about the language of the arbitration? They may think that they would be at a disadvantage if the language of the arbitration is English. Of course, if Chinese were chosen, the American side is likely to be at an even greater disadvantage because they are likely to be less familiar with Chinese than the Chinese side is with English. It would not make sense for the parties, for example, to choose a third language. So what is to be done? Are there real concerns? Can anything be done to remove or reduce the disadvantage? The disadvantage is unlikely to be substantial if, as is usually the case, the parties have been able to negotiate and correspond in English. One obvious disadvantage for the non-native speaking side is that their witnesses would probably prefer to give evidence in their own language, even if they are proficient in English. That is understandable, and their choice must be respected. Because of that, there's the fear that something might be lost in translation. That is a legitimate concern. I believe, however, the party could reduce the disadvantage to an acceptable level if it appoints a bilingual arbitrator. Agreement on the choice of language may be difficult to reach. Certainly, the language should be carefully chosen. A relevant consideration is the nature of the evidence. How important will witness evidence be, and what type of witness evidence? If they are technical, language is unlikely to matter much. What if memory or credibility is involved? There, I think one should bear in mind the well-known observations of Mr. Justice Leggett in Jasmine. He said, the best approach for a judge to adopt in the trial of a commercial case is, in my view, to place little, if any, reliance at all on witnesses' recollection of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary evidence and known or probable facts. End of quote. I agree. In fact, I have little doubt that in commercial disputes, inherent probabilities based on the totality of the evidence is a more reliable guide than memory or recollection or credibility, and decisions are normally made on such basis. In an arm's length deal, where both parties have the same bargaining power, I believe in deciding on language, one should be guided by practical considerations. The choice of one's native language, because it is one's native language, is not necessarily a good practical choice. In a typical case, a lot of the documents, including sometimes contractual documents, and almost always correspondence, pre-contractual or post, would be in English. If Chinese is chosen, they would have to be translated. That would take time and money and lengthen the hearing. Here, there's also the risk of inaccurate translation. Moreover, it is often more trouble than it is worth, especially when the non-native English-speaking side has little difficulty with English. The choice could be made easier if a tribunal would be as accommodating as possible over the use of language in an arbitration. Personally, I see no reason, if the advocate on one side wants to use the language of his party, that should not be permitted, subject, of course, to interpretation and translation if necessary. For example, an advocate might prefer to make the closing submission in English, although the language of the arbitration is Chinese. I think a party should be permitted to use as much of its own language as it wishes. The official chosen language, of course, has its special status. For example, subject to the agreement of the parties, the award would be in that language, and the record will be kept in that language. If the parties use the language most appropriate to the dispute, they may find that the dispute can be more easily understood by the tribunal. If arbitration is a collaborative effort, as I believe it should be, and the common goal is efficiency and fairness, should an agreement say anything about the language capability of the arbitrators? I'm not aware of any language requirement for the appointment of arbitrators. It is assumed that an arbitrator would be able to conduct the arbitration in the language of the arbitration. I don't believe any rule actually requires that. But I think it is highly unlikely that a person who cannot understand the language of the arbitration would be appointed. But it makes sense for a party to appoint someone who can understand its language. In an agreement providing for the appointment of a single arbitrator, I see no legal impediment to stipulating that the arbitrator should be bilingual in the relevant languages. in agreements which provide for 3 arbitrators, one can appoint a bilingual person as one's party-appointed arbitrator. Subject to the question of common nationality, I see no reason why the parties could not agree that the presiding arbitrator must be bilingual. I have not seen an arbitration agreement providing for bilingual arbitrators. There may be practical difficulties. For example, it may limit the pool of available arbitrators. But parties should be aware of the potential benefit. The advantage of bilingual arbitrators is obvious. They will be better able to follow the proceedings. Party-appointed arbitrators must, of course, be neutral. They are not the champions of the parties appointing them. But one might prefer to appoint someone who can understand one's case without interpretation. Then nothing will be lost in translation. Party autonomy means, subject to irrelevant consideration, an appointing party is allowed to appoint an arbitrator of its choice. Parties, however, generally do not have any say on the appointment of the other party's arbitrators. But in the choice of the presiding arbitrator, practically speaking, both parties have a say. Ability to understand both languages should be a relevant consideration. As a compromise over the choice of language, the parties may consider stipulating that, subject to the question of common nationality, the presiding arbitrator should be bilingual. There is, of course, the possibility that an arbitration agreement may provide for 2 languages. I say nothing about that. Maybe in Canada, there is experience of that. I turn to the role of the courts in an arbitration. They are the courts of the seat, the courts of the venue, and the courts where an award is enforced. I'll deal with them separately. A well-drafted agreement should stipulate the seat of the arbitration. The seat is important since the applicable system of oversight and supervisory jurisdiction of the domestic court comes with it. But one should not overstate its importance. In most arbitrations, the court of the seat is not called upon to do anything. The seat is very often not the jurisdiction where enforcement would be sought. Enforcement is normally sought where there are easily accessible assets. The court where enforcement is sought is, in my view, in practice, the most important court in any arbitration. Maybe that is why Lord Mustill singled it out for mention. Popular seats, such as London, Singapore, or Hong Kong, are not chosen because the parties have assets there. Normally, they are chosen because the parties are familiar with the legal system there and the available legal services there. However, I've seen Paris chosen, although the parties have no desire ever to resort to the French court, and French law has nothing to do with the arbitration law, nor the French language for that matter. I think Stockholm is another example. Very often, the seat is chosen almost as a formality. That is because it is uncommon for resort to be made to the seat. Is politics a concern in its choice? Let us think about it. Say country X is the seat. Remember that an award may be enforced virtually all over the world. Even in Afghanistan and North Korea, although it appears that they have not adopted the untrial rules. For obvious reasons, awards are enforced where there are readily accessible assets. The seat of an arbitration often has little to do with the presence of assets within the jurisdiction. As I've said, popular arbitral seats, such as London, Singapore, and Hong Kong, are rarely, if ever, chosen because the parties have assets there. What mischief can the court of the seat do? It could, theoretically, in the exercise of its supervisory power, set aside or annul an award. Here, the supposed fear is that for political reasons, the court of the seat sets aside or annuls an award. I think that fear is unreal. Anyway, the generally accepted view is that neither setting aside nor annulment by the seat would necessarily preclude enforcement of the award elsewhere in the world. I believe certainly not, if the decision to set aside or annul was politically motivated. Thus, one can see that the role of the court of the seat is very limited, and politics should not be a concern. As I've said, the choice of a seat rarely has anything to do with enforcement of the award. If one has to enforce an award, let us say in an authoritarian state, one does so because that is where the money is. If that place happened also to be the seat of the arbitration, that would be a coincidence. If there are political risks at the place of enforcement, there's very little one can do about it, short of refusing to do business with a party who only has assets there. Similar considerations apply to the venue. The chosen venue is often different from the seat. It is normally where the arbitration is conducted. In practice, the venue is more important than the seat. Again, a venue is not chosen because the parties have assets there. Sometimes, I think only occasionally, in some arbitrations, the court of the venue is asked to give interim measures. Interim measures, of course, are not final awards. The risk of politics intruding into the venue of an arbitration is fanciful. It is therefore my opinion that politics should not be a concern in the choice of the seat or the venue. Their courts have no practical influence over the result or enforcement of an award. As I said, the venue is chosen normally for its amenities. The most important of which are the availability of a good and user-friendly legal system and legal profession, local and foreign. A user-friendly immigration policy is also essential. I believe the party's choice of the venue should bear these considerations in mind. I live in Hong Kong and am familiar with Hong Kong, and I shall use Hong Kong to illustrate the qualities which parties may bear in mind when they choose the venue for their arbitration. Hong Kong has a large expatriate community led by nationals of the United States, United Kingdom, Canada, United Kingdom, and France. According to available statistics, there are about 85,000 US nationals in Hong Kong as of 2018. the number of Canadians in Hong Kong are substantially higher. There are about 33,000 UK nationals in Hong Kong, of whom 19,405 are of European ethnicity. The rest are Chinese, Indians, Pakistanis, and so on. I believe the number of UK nationals are small because holders of some British passports have been excluded from those numbers. As of 2014, approximately 300,000 Canadian citizens of all ethnic backgrounds live in Hong Kong. The French consulate estimated that there are about 25,000 French citizens in Hong Kong. So Hong Kong is truly an international city. I do not have the figures, but the number of Hong Kong residents who have been educated out of Hong Kong must be very large. We have a large number of returned students from the States and the United Kingdom. So we have strong international connections. That is Hong Kong's strength and why it is a popular choice as a venue for arbitration. We also have a government which is highly supportive of international arbitration and has actively promoted international arbitration since at least the 1980s. More relevantly, we have a vibrant and independent legal profession in Hong Kong. There are over 11,000 solicitors with practicing certificates in Hong Kong. They are usually solicitors in active practice because professional insurance is expensive and insurance is needed for the issuance of a practicing certificate. There are 1,500 odd solicitors without practicing certificates. I believe a large number of them are in-house lawyers. In-house lawyers, of course, do not have to be qualified or registered in Hong Kong, and they come from different jurisdictions. And there is a strong community of in-house lawyers in Hong Kong. There are also 1,460 odd registered foreign lawyers. They are lawyers who are qualified in overseas jurisdictions who can practice the law of the jurisdiction in which they are qualified. If you look at the list of firms, local and international, practicing in Hong Kong, you see they read like a who's who of all the leading firms in the world. Hong Kong has also a very strong bar. There are 1,600 barristers, amongst whom about 100 are senior barristers. There are currently also 1,018 persons on the panel of arbitrators at the Hong Kong International Arbitration Center, representing 60 nations and territories, including Hong Kong. I have no doubt international companies would have no difficulty recognizing the caliber of the arbitrators on the Hong Kong International Arbitration Center's panel. I don't believe that there can be any real doubt that Hong Kong is an ideal place as a venue for arbitration. Administrators. Time for a little plugging for the Hong Kong International Arbitration Center, of which, as Sarah said, I'm a council member and have had a long association with the center. HKIAC is well known for the efficiency and helpfulness of its staff. It is often appointed as an administrator of international arbitration in Hong Kong. There are, of course, arbitration in Hong Kong where the administrator is not HKIAC. For example, the ICC has a substantial presence in Hong Kong. There are also arbitrations where no administrator is appointed. In choosing an administrator, it may also be relevant to consider how arbitrators are remunerated in arbitrations administered by the administrator. One advantage of an arbitration administered by HKIAC is that arbitrators may be and are often remunerated on a time basis, subject to a cap which can, by agreement, be removed. I think that is a fair system. In arbitration administered by some other bodies, arbitrators are often only paid ad valorem based on the size of the claim. I've heard it described as feast or famine. The advantage of payment on an ad valorem basis is that one knows in advance how much the administrator's fees are likely to be. For example, one knows that when the amount in dispute is US 3 million, at the ICC, the maximum fee per arbitrator is US dollars $114,080. The disadvantage of feast or famine is that sometimes one is paying too much and sometimes too little. Neither is desirable. Paying too little is particularly bad. That is because good arbitrators may not be prepared to be appointed unless they are reasonably confident that it will not be a famine. Some arbitrations are important to the parties, although the claim may be relatively small. These arbitrations can be very complicated and time-consuming. The maximum fee per arbitrator may be totally unattractive to an experienced arbitrator. Where the remuneration bears no proper relation to the amount of work involved, desirable arbitrators may be unavailable. Now I turn to the enforcement court. The last runner in Lord Mustill's example is the enforcement court, which could be situated anywhere. Given the international footprint of large international concerns, arbitral awards can be enforced in any number of different jurisdictions until it is fully satisfied. Although an enforcement court is chosen by the party seeking enforcement, the choice is very often driven by matters outside its control. If there are political or other risks at the relevant jurisdiction, there's nothing much one can do about it, short of never contracting with a party whose assets are situated within such jurisdictions. I come to the most important choice that one makes in an arbitration, and that is the choice of arbitrators. The importance of arbitrators requires little explanation. Their decisions are well-nigh unchallengeable. Naturally, they must be independent and competent. Quality is important in complex international commercial arbitration. One advantage of arbitration over litigation is that the parties have a say in the composition of the tribunal. What quality should one look for in an arbitrator? Arbitrators are required to be neutral and independent. A party-appointed arbitrator owes no loyalty to the party appointing them. Quite the contrary. When they accept appointments, they are required to affirm that they are indeed independent. Happily, in Hong Kong, arbitrators are known for their independence, so that is normally not a concern. No credible regime of arbitration can survive, unless the independence of arbitrators is beyond doubt. In Hong Kong, there is no doubt. So what are the qualities one should look for in an arbitrator? The appointment of arbitrators is the single most important decision a party makes. Professionalism is first and foremost the quality to look for, and someone with the experience of, and one should look for someone with the experience for the work required. A person who is willing to put in the necessary work and who will be able to truly follow the proceedings and understand the dispute. This may sound easy enough. I've often heard it said that a good advocate is one who can make black white. To my mind, a good advocate is someone who can show white is white. That is more difficult than you may think. I'm talking about cases where both sides genuinely and reasonably think that they have a viable case. There are cases where the result could go either way. Maybe it's a 50-50 case, maybe 55-45, 60-40, and so on. They make up the bulk of the dispute. In a complicated case, making the tribunal see that one's case is better than the other side is more difficult than one might realize. Sometimes what appears to be straightforward to a party is not necessarily so to the tribunal. That is not because the tribunal is stupid, not at all. The parties and their representatives have lived with their case for a long time. They know it inside out. But the tribunal is likely to have spent much less time in the matter. Also, the advocate for the other side might be able to present his case more attractively. So important considerations when it comes to the appointment of arbitrators are their ability, the capacity for hard work, their ability, and the quality of their judgment. One will want someone who can tell a good point from a bad. If you have a good case, you want an arbitrator who can understand it and will not be misled, no matter how skillfully the other parties puts his case. To conclude, I believe an arbitration works best if parties can work together and make it a collaborative effort. They should be guided by practical consideration when they agree on the choice of law, language, seat, and venue. They should aim at appointing a tribunal suitable for the difficulty or complexity of their dispute. If they do so, there's a higher probability that the arbitration will be efficiently and fairly run, and no cost and money will be wasted. Thank you very much.
Thank you very much, Robert, for your thoughts on all of the participants in the arbitration process. We now have a few minutes for Q&A, and we have received some questions. Let me raise them to you. The first two questions we have are on quarantine in Hong Kong, as well as the adoption of the national security law. And I'll come back to those, but then we also have two other questions with respect to your career as a judge. The first is, have you adapted your approach to deciding disputes as an arbitrator compared to your approach as a judge? And then the second question in that respect is, do you think it's daunting for parties to plead Hong Kong law to you as a former judge of the Hong Kong Court of Final Appeal? What would you say to those two questions first, Robert, and then we'll come back to the other two?
Sorry. I think working as a judge and working as an arbitrator is very different. Judges work in situations where every participant are on the same page as you were. They are trained in the same system of law. They talk about things that they are all familiar with. As an arbitrator in an international dispute, it is very different because one is often dealing with people from different cultures. Their understanding, their way of doing things may be very different. Take the mainland and Hong Kong, for instance. It is much easier, I think, for a Hong Kong judge dealing with a dispute involving only Hong Kong parties. If one has a party which comes, say, from the mainland, then very often one would find that things are done in a way that one is completely unfamiliar with. I think in arbitrations too, one is likely to be dealing with parties from very different cultural backgrounds. And also in the writing of one's decision, one's approach is very different because as a judge, one is writing judgments which one believes the lawyers for the parties themselves, and the Court of Appeals, if any, should be able to understand. A lot of things can be left unsaid. In an award, it is very different because one is addressing a different audience. And when it comes to enforcement, one's award may be read by judges who are trained in a completely different tradition. And that is why awards tend to be longer than judgments. Because in some jurisdictions, for example, form is as important as substance. Whereas in Hong Kong, I think in common law countries, substance is very much often much more important than form.
Thank
now,
you.
As for whether it is daunting for a party to address me on a matter of Hong Kong law, I don't think it should be daunting at all, because I always find it embarrassing to say to people, especially laymen, because lawyers will understand, how little law one actually knows and how much one actually has to continue to learn about the law. And in a lot of situations, if it is necessary for lawyers to address one on the law, it is because the law, because it may involve a novel point, or that it is not straightforward. And if it is novel or not straightforward, then I think any tribunal worth its salt will be willing to listen to it carefully, think about it carefully too, before coming to a decision on the matter.
Thank you, Robert. I think that will be very encouraging for those who may appear in front of you in the future on Hong Kong law. The other two questions, so the first was with respect to quarantine in Hong Kong. The first question was, has Hong Kong's strict quarantine rules driven parties / arbitrators away, or can one still work in hotel rooms? I don't know if you will necessarily know the answer to that, Robert, but do you have any experience on dealing with arbitrations where Hong Kong's quarantine rules or the quarantine rules from another jurisdiction came into play and you had to deal with that?
Well, I think that's been the common experience. I've conducted arbitrations where people are scattered around the world. That can pose logistical problems because one has to accommodate people in different time zones. But I think given proper cooperation, it has not proved to be difficult at all. I think the trouble with virtual hearing is that they can almost become addictive because they are so convenient. So I don't think it has been a problem in my experience that witnesses may not be able to come to Hong Kong. I think it is something that one can deal with without very much of any hiccup at all.
Thank you. And then the last question we have is with respect to the national security law in Hong Kong. The question is, do you think that this has affected the attractiveness or confidence over Hong Kong as a legal hub in the region? Do you have any comments on that? And I would in particular be interested to hear from your point of view as someone who has had such a long career in the judiciary in terms of how that law may affect, if at all, how one would approach arbitration-related matters before the courts.
Well, as I'm still a non-permanent judge, I don't think I should really comment on that. But in the course of my talk, I did say that I don't think politics is a relevant consideration when one considers the choice of the seat of an arbitration or the venue of an arbitration. And that is my view.
Thank you very much, Robert. And of course, you do still a non-permanent judge on the Court of Final Appeal at the moment. So, this brings us then to the end of this session. And I want to thank you very much, Robert, for your time and for your thoughts today that you have shared with us. I also want to thank all of the attendees who have listened and posed questions. Thank you very much for your questions. Unless there are any more questions that pop up immediately, then I think we will bring this session to a close. And we wish all of those of you who are in Seoul a very good rest of the week, and to all of the organisers of the other sessions, a very successful ADR Festival. Thank you very much and all the best.
Thank you. Goodbye.
Bye-bye.